minutes each to following the guidelines I gave in my communication.
Thank you, Mr. Speaker. Mr. Speaker, on behalf of the Legislative and Litigation Caucus, chaired by the Honorable Samuel Chepkonga and myself, and a number of members are part of us, those who are present here. I see Honorable Mutuse, Honorable Gishimu, Honorable Murugara. I see my friend Kiremba, among others. Mr. Speaker, as we already indicated to this gathering in Naivasha on 6th of February.
Senior counsel, is Karemba also a lawyer?
No, as you know, Mr. Speaker.
Or is a cheerleader?
There are 3 non-lawyers who are ably assisting the team.
Okay.
With the matters that may not be legal, but are pertinent, pertinent to this House. And the 3 non-lawyers include Honorable Dawood, Honorable Zamzam, and Honorable Kiremba. They are ably assisting us. Mr. Speaker, on 6th of February, the Court of Appeal gave a very well-reasoned and solid judgment delivered by the President, Justice Musinga, together with Justice Tuyot and Justice Muchelule, in 63 pages. Mr. Speaker, as the caucus, we've taken the time to synthesize it into just 2 pages, which we've shared on the wall, for members who do not want to read too much legalese. Mr. Speaker, we want to say very briefly, first, there are certain points we had raised before the High Court and later before the Court of Appeal, but in which we were not successful in the High Court. And so on the appeal, we raised 18 different points. And I'm happy to say, Mr. Speaker, that we succeeded on 17 out of the 18, except one which I will speak to. But it is important, Mr. Speaker, that this judgment is considered in its proper context. This judgment establishes certain constitutional principles that are very important. One, it disabuses this notion that the CDF may be interfering with devolution. And the court importantly observes that devolution is different from decentralization, and that is, these are decentralized funds. And you cannot stop national government from determining how it is decentralizing. Mr. Speaker, I beg that since I am helping members not to read 63 pages, I be given a little more time. Thank you. Mr. Speaker, secondly, there was this myth of division of functions, and that the CDF interferes with the division of functions and also interferes with the devolved funds. And the Court of Appeal was able to demonstrate that the entire CDF is restricted to what is already allocated to national government. Mr. Speaker, the court then went on to deal with the question of is CDF a unit of service delivery? Quoting the National Government Coordination Act, the court was able to establish that the constituency is a service delivery unit. And you cannot say that merely because it's called constituency, you cannot use it as such. And that is very important, Mr. Speaker. The court importantly found that there is nothing in the doctrine of separation of powers that makes NCDF unconstitutional. In fact, the court finds that it is quite consistent with the doctrine of separation of powers, and the myth that MPs and control CDF was found to be a myth without foundation and supported by fact, and that is very important. Mr. Speaker, the court importantly finds that on the question of the constitutional principle of public finance, NGCDF is quite consistent. And it also says that there is no need and there was no need to involve the Senate, either in enactment or amendment of the CDF Act. And that is very important to know that even today, if we choose to enact, amend, we do not have to go to the Senate. Mr. Speaker, the court found that there's a presumption of constitutionality. This thing of starting by presuming that everything Parliament has done is unconstitutional should be the other way around. The court should start by presuming that Parliament in its wisdom acts constitutionally. And unless the person challenging it is able to demonstrate, then what Parliament has done should be sustained. Mr. Speaker, It is also important to understand that there's only one respect in which the court did not agree with us, and that is Section 43 of the Act, which talks of the tenure of the fund account manager. And the court found that that particular section is inconsistent and should be severed. Mr. Speaker, it is my advice to the team that even that we agree with, because in truth, that section is misplaced. The fund account manager is not an employee of a member of parliament. The fund account manager is an employee of the board. So how long they serve is neither here nor there. So we have no business appealing that. In fact, we agree with the Court of Appeal on that. We are happy to sever that and remain with the act as it is. It is important, and we thank the judiciary for its sensitivity in terms of timing. The decision has come at the last possible moment, knowing that by 15th, which is just next week, the budget policy statement has to have been rendered to this House. Had we not gotten a decision in time, then we would not have been able to factor in the CDF for the next financial year. So it is quite timely. Mr. Speaker, it is also quite timely because the High Court had decreed, but by the fall of midnight of 30th June, every project, every activity, every employee, and everything to do with CDF ceases. So all those who are employed, whether it's in the constituency level, at the national level, and all those projects, the sword of Damocles was hanging over them. And that uncertainty was already starting to affect so many employees who are starting to exit before the fall of that hammer. And so it has become very timely. Two more points, Mr. Speaker. It is important to understand that when we celebrate this decision, we are not celebrating it for the members of parliament. We are celebrating it for the citizens of this country. The fees we pay in terms of bursary is not for the MP. The classrooms we construct is not for the MP. The labs and dormitories we do, the fencing and gating. Mr. Speaker, all these things that we do, whether it's in terms of police, the chiefs, environment, it is for the citizens, not for the member of parliament. And if there are instances of abuse by any individual member, that should not be visited on the concept or on the act. And some people readily come and say, oh, you should disband CDF, give it to the governors, as if the governors are any cleaner than members of parliament. Or even if you took it back to the executive, as if the executive are the saints and saviors of our time. In all these sectors, there can be abuses, but each abuse must be dealt with individually. Lastly, Mr. Speaker, and I am happy that the Court of Appeal disabused this notion. A lot of people will stand and say, the work of a member of parliament is to legislate, represent, and oversight. And they speak it so many times that it starts to sound like an absolute truth. Mr. Speaker, there's nowhere in the Constitution which states explicitly that the only work of a member of parliament is legislation, representation, and oversight. Nowhere. It is by deduction of various other parts of the Constitution. But even those parts do not say only. Unless the Constitution says they only work, then by deduction, you can do those three and still do more. In fact, Mr. Speaker, I want to invite my colleagues. Do not listen to such statements. Go straight to Article 95, 95(2). What does it say? The work of the National Assembly is to discuss and resolve matters of concern to the citizens. The key word is resolve. If in your village, what is the biggest problem is a mudslide, then you are required to find a way of resolving it. If in your village it is death and people want to give people decent burial, it is part of your work to represent and resolve it. If in your village it is roads, although it's not in our mandate, you must find a way of resolving those issues of roads, of floods. In some instances, it gets to ridiculous levels. Even those who are going to pay dowry want you to help them resolve how to marry. And when they want to claim that dowry, they also want you to help claim. And if that is what concerns them, it is your duty. Those very people who are telling you it's not your work, and you come here and do representation as gallantly as we defended. We bear no ill will with the High Court that did not agree with us, because that is the nature of the law. I urge our colleagues to embrace this finding, to be confident and not to fear, to avoid vilification, but